Well, good morning, all. We will make a start here. You're very welcome to this next edition of our Life Sciences Legal Forum. We send out feedback forms at the end of every session, and competition law and antitrust issues in the context of the life sciences sector constantly sort of appears towards the top of the list. And I'm delighted today to introduce two senior lawyers from our competition law team to talk about some of the competition law issues that we are seeing within the sector. So Kate Newman, is partner who heads our competition law team, and Nicola Holmes, who's a senior lawyer in the competition law team, both of whom have massive experience in the sector. Please do ask questions as we go. So if you have questions that you want to ask the panelists, please do use the Q&A function within Zoom, and we'll pose those questions of Kate and Nicola as we go through. I think what we probably will plan to do is to have a sort of a formal Q&A session towards the end. But if people got specific questions as we sort of talk through some of the themes, then please do raise them as we go on. Your feedback's really important. So at the end of the session, we will send you a feedback form, and that gives you the chance to make some suggestions for future sessions. The next session we are going to run is in September, which will be looking at regulatory trends within the sector. So let's get going. So the sector continues to be a priority for the competition law authorities. And first of all, I'm keen really just to get a sense of the sort of enforcement activity, and to understand some of those current trends in enforcement. I think from our discussion before this, I think you thought, Nicola, that a lot of it focuses still on pharmaceuticals. But yeah, can you give us some initial thoughts in terms of where some of those trends are?
Yeah, of course. Thanks, James, and good morning, everyone. You're absolutely right. It's really clear that the sector, in particular pharmaceuticals, remains an enforcement priority for the competition authorities. In January of this year, for example, the European Commission published a report giving an overview of their activity in this sector. The focus, again, is on pharmaceuticals, but in the period covered by their report, which was 2018 to 2022, they adopted 26 antitrust decisions in the sector. So that is decisions relating to either anti-competitive agreements or abuse of a dominant position. And they have continued to emphasize in speeches and communications that the sector remains high on their list of priorities. Here in the UK, the picture is very similar. Again, the Competition and Markets Authority here in the UK has 5 open cases in the sector. What we're seeing in terms of trends, though, the sort of the type of cases that the authorities are focusing on is changing a little bit, and we've seen a dropping off in the number of new pay for delay type cases. So pay for delay, you'll recall, is where the incumbent pharmaceutical manufacturers make payments or transfer benefits to new generic entrants in order to delay or limit their entry onto the market. So pay for delay. We're seeing a drop off in those kinds of cases, and we've seen a rise in so-called disparagement cases.
Disparagement. I mean, yeah, I think we're seeing some of that in practice as well, aren't we? Can you just tell us a bit more about those types of issues, Nicola?
Yeah, of course, disparagement. So the French competition authorities have actually been the leader on this type of case. And these cases involve misleading information or communications about a rival product that discredits the rival. So in particular, usually focusing on the safety or efficacy of the rival product. And these are deliberately misleading communications, which are being used as part of a competitive strategy to reduce competition from the rival. And it's not theoretical. We have a recent example in the Vifor case. So in January of this year, the UK Competition and Markets Authority announced that it had launched an investigation into Vifor Pharma, and that's over its suspected anti-competitive conduct in the supply of intravenous iron deficiency treatments for NHS patients in the UK. To give a bit more context, Vifor makes Ferinject, which is a leading IV iron deficiency treatment in the UK. And the CMA is looking at whether Vifor has restricted competition by making misleading claims to healthcare professionals about the safety and effectiveness of Monofer, which is a rival high-dose IV iron deficiency treatment supplied by Pharmacosmos. So the concerns, though, aren't just limited to the UK. Vifor is actually also subject to a parallel investigation in Europe. The European Commission opened their investigation in June of 2022, so a little while ago, and they're also looking at whether Vifor has restricted competition by disseminating misleading information about Monofer. And the Commission thinks that may have delayed uptake of Monofer within the whole EEA. The Commission's timetable is actually running a little bit ahead of the CMA, so they've actually provisionally concluded that Vifor Pharma may have abused its dominant position in the market for IV iron treatments in 9 member states by illegally disparaging Monofer, Pharmacosmos's product. So in April of this year, to bring us right up to date, the Commission announced that they're consulting on commitments offered by Vifor to bring their investigation to a close. So this is the commitments process allows a company under investigation to offer meaningful commitments to bring the conduct to a close, which has the effect of bringing the investigation to a close sooner than it might have done. Under the proposed commitments, Vifor Pharma's proposing that they'll launch what's described as a comprehensive and multi-channel communications campaign to rectify and undo the effects of the potentially misleading messages regarding the safety of Monofer. And additionally, for a period of 10 years across the entire EEA, so not just the 9 member states where the conduct has been found, but across the whole of the EEA, Vifor has, under the commitments, would agree not to engage in any external promotional or medical communications in writing or orally about Monofer's safety profile using information that isn't based on either Monofer's own summary of product characteristics, so its own SPC, or derived from randomized, controlled clinical head-to-head trials. So they won't engage in any communications that aren't based on either the SPC or their own trials. And it's also got to implement some measures to ensure safeguards to ensure compliance. So it's a pretty comprehensive package, and it's proposed that those commitments would remain in force for 10 years. So it's quite a material commitment.
Absolutely.
Yeah, the Commission's obviously really concerned about this kind of disparagement conduct. So as well as the Vifor investigation, they've also got an ongoing case against Teva in relation to similar conduct, alleging that Teva has misused the patent system, but also disparaged a rival multiple sclerosis medicine in order specifically to hinder competition to Teva's Copaxone, their blockbuster medicine. The package of commitments that Vifor have offered is out for consultation at the moment, and the CMA will be cooperating closely with the Commission on the Vifor case, as obviously the 2 investigations cover the same conduct. So it'll be interesting to see how that proposed commitments package influences the CMA's direction of travel as well.
That's really, really interesting, Nick. And I'm assuming, although a lot of these cases have focused mainly in terms of pharma, there are learnings across the sector, whether we're talking about devices, etc. So I'm keen to really just understand some of those learning points then in relation to when you're engaging in advertising and promoting these kinds of products and these sort of those lookouts, as it were.
Yeah, Absolutely, and you're 100% right. Although this is a pharma-specific case, there's read across for any entity engaging in advertising and promotional activity. I mean, it's fair to say that these disparagement cases are fairly new ground for both the Commission and the CMA. So there isn't yet from them really clear guidance as to what will constitute anti-competitive disparagement. However, as I said, the French competition authorities are a little bit ahead, and they do have a number of settled decisions, and you can take from those cases some key elements that will likely have to be present for disparagement to constitute a competition problem, and that companies therefore need to avoid. So I think firstly, we're looking for statements put out into the market that are not based on objective findings or verified assertions. So you can see from the Viafor commitments that they'll be tied to making only assertions that are specifically based on Monifer's SPC or on properly conducted trials. So if you're disseminating information which is misleading, incomplete or ambiguous in a way which is intended to instill doubt in the market, that can form the basis of a disparagement abuse. So companies will obviously need to take care that their marketing and their information is clear and truthful, but obviously based on objective evidence. So it's really tied to the known facts. I think the other element is that there's got to be a link between the dominance. To establish an abuse of dominance, there must be a link between the dominance and the denigration. That might be, depending on the facts, that might be quite easily established if the company putting out misleading information has a really strong reputation in the market. So they've already got an established position of trust, and also if the communications are very widespread. So if you've got a very established, strong network of comms through a network of health professionals, I mean, the bigger your expected impact from your communications, the more care you must take to avoid unfair disparagement. Some of the French cases noted in particular that healthcare professionals may be sort of naturally cautious, and also potentially overwhelmed with kind of large volumes of marketing information. So they may struggle to stay on top of that. So they're going to pick out key pieces of communication from trusted companies first. And so if you're in that position, you do need to take extra care with what you're putting out. Finally, I think intent is also highly relevant. So although the concept of abuse of a dominant position in competition or is an objective concept, actually in this context of disparagement, the authorities will be looking for any evidence that a misleading communications campaign or an ambiguous communications campaign forms part of a wider strategy by an originator pharma company, for example, looking to hinder generic competition. So they'll be looking for evidence, more broadly than just this one piece of communication, that actually it forms part of a strategy to hinder competition, to delay, to block new entrants to a market. It's also worth mentioning, of course, that pharma and medtech and medical devices have their own codes of conduct and other sort of separate codes of practice for advertising, which they'll need to adhere to as well. And actually sticking to and referring to those codes may be helpful to defend a piece of communication, to show that it was not part of an anti-competitive strategy. It in fact complied with the existing codes of practice.
Yeah, and those codes are almost the form of the benchmark, don't they, for what is appropriate behaviour.
They could form a baseline, certainly, for what would be acceptable, and then we would be looking for something that's beyond that, that's not normal under those codes. I think it's also worth mentioning that, as well as actual marketing and promotions campaigns, companies should also be mindful of what they say in other forms of corporate communications, such as investor relations or analyst briefings, to the extent that those touch on the market view and rivals. It is also important to make sure that those communications are appropriate as well.
Yeah, there's actually a question that's been raised by one of the audience members, Nicola, on that. which is actually were, and I think it ties into the industry code point. So were complaints also made to local regulatory bodies as well, such as the PMCBA, etc. I think in relation to those, I think the answer is yeah.
Yeah,
Yes, they
absolutely.
were. Yeah.
Vifor is an interesting one because the battle between Vifor and Pharmacosmos has been raging for quite some time, and there have been a number of rounds of complaints at the PMCPA as well. So yes, definitely those kinds of complaints can still be made in that forum. I think that taking it to a complaint about breach of competition law is a kind of level up from that.
Yeah.
Pharmacosmos maybe feels that their actions under the codes of practice haven't produced the necessary. They will feel the necessary change in Vifor's behaviour. So now it is definitely a level up to take it to the competition authorities.
And I think it's worth noting that actually, so some of these codes, such as the ABHI code, they require, before you make the complaint, they require engagement between the parties. So there's an onus to try to sort out those
yes,
issues.
Absolutely, and that wouldn't be necessary in a competition
absolutely.
Claim.
There's also a follow-up question which I think is linked to this, which I'd probably like to ask now as well, Nicola, because it does relate to marketing activity. So when a company has been investigated, is there personal liability, such as for CMOs, so chief medical officer, that have signed off marketing materials?
Well, in the UK, we do have the possible sanction of director disqualification. So where the UK Competition and Markets Authority finds that there's been anti-competitive conduct, they will usually pursue, as a matter of policy, director disqualification orders against directors who've been involved in the conduct or who should have known about it. So there is a possibility that if the UK CMA concluded that there had been a breach of competition law, that they would pursue disqualification orders against the relevant directors. However, I think that is it's a little bit speculative at this point, because it remains to be seen whether they'll be able to conclude that there has been the necessary breach in the UK. And it's also worth noting that director disqualification doesn't exist as part of the European Commission's toolbox. So at the European level, that's not personal consequences won't flow from this, except separately if there's employment consequences as between the company and its own directors.
So maybe we can move on from sort of disparagement type cases to look at some other case trends we are seeing, Nicola. So what other cases have the UK competition authorities been looking at in our sector?
So as I said, the CMA has been a very active enforcer in the life sciences sector, particularly in relation to pharmaceuticals. I'm afraid it is still focused largely on pharmaceuticals. They've taken several decisions on excessive pricing. So excessive pricing is an abuse of dominance, and it occurs when a dominant supplier charges in summary prices which bear no reasonable resemblance to the economic value of the product, and which are excessive and unfair. So this is an abuse of exploitation, where a dominant firm holds a sort of captive market, and they exploit those customers by excessive pricing. These case investigations have often been triggered by very steep, kind of eye-watering price rises. So in the CMA's case relating to liothyronine, the price of the relevant tablets was said to have increased by over 1,000% over 8 years. So really staggering increases. So those excessive pricing cases involve unilateral conduct by a dominant firm. But the CMA has also looked at several cases involving anti-competitive agreements. So that is usually where an incumbent supplier is trying to limit competition from new generic entrants by entering into anti-competitive agreements. In May of this year, actually, the CMA suffered a little reversal of fortune in respect of some of those cases. So the Competition Appeals Tribunal handed down judgment in an appeal on one of those anti-competitive agreements cases, this one relating to prochlorperazine. this was a case that had begun with Dawn raids in 2017, and the CMA reached a decision in 2022 that there was this kind of pay for delay agreement between Alliance and two would-be competitors. So the agreement essentially involved Alliance paying the two competitors, the CMA said, not to compete in the supply of prochlorperazine. And this arrangement was achieved in the guise of various distribution agreements. So it's quite a complicated fact background, but Alliance entered into agreements with these two would-be competitors, which the CMA said were effectively agreements not to compete. And the CMA found that those arrangements had resulted in prices rising by 700% over a 4-year period. And you can see it was quite complex because, you know, the raids were in 2017, the decision was only reached in 2022. And here we are in 2024, and the CAT has just, the Competition Appeals Tribunal has just unanimously allowed the appeals and set aside the CMA's whole decision. The CMA is applying for permission to appeal, so it is a kind of watch this space. But an important point to come out of the Competition Appeals Tribunal judgment, which I wanted to mention, is that the CAT noted that the CMA's decision had been heavily based on inferences. And that's not uncommon in competition cases, because with an anti-competitive agreement, you know, the evidence may be pretty sketchy and, you know, kept hidden by the participants. But the CAT wanted to stress that there must still be clear evidence, and they noted that the UK generics market can be very complex, and it is very important that all of the regulatory and pricing context is taken into account when we're looking for conduct in this sector. And the CAT noted that steep price increases are possible and maybe even expected for at least a short period once an out-of-patent drug is genericized. So I think it's an important kind of reminder to the CMA that sharp price increases don't always mean anti-competitive conduct, and the context is going to be very important. So it'll be interesting to see what comes of that appeal as we progress.
So watch this space.
Watch this space, yeah. Watch this space.
Yeah. I'd like to bring Kate into the discussion now. So as I said at the outset, please do feed questions through the Q&A function on the on Zoom. But Kate, I wanted to sort of turn to the annual plan, 2024-2025, which the CMA has announced, and its intention within that plan to tackle competition concerns in labour markets. So I'm keen to really understand what's the driver for this, what's the CMA focusing on, and really just to understand some of those implications for the life sciences sector.
Yes, thank you, James, and good morning, everybody. So yes, this is a hot topic for the CMA, but I would also, I suppose, note as an aside, it's a topic that's been rumbling on in other jurisdictions for some time. So, for example, the national competition authorities in Poland and France have also been looking at issues in this area. The US authorities have also been very active, and our understanding is that the European Commission is also looking at this topic. I suppose by way of backdrop, historically, practices concerning labour markets, I think, might have been perceived as being within the realm of employment law. However, recent statements by the competition authorities, including the CMA, as well as recent enforcement action, I think has thoroughly dispelled this perception. And it seems very clear now that anti-competitive collusion between employers is illegal under the competition rules. And importantly, this really is a risk area. Well, it's for all sectors of the economy and all organisations within the life sciences sector. And like the cases which Nicola was discussing, which really have been in pharma, thinking about originators and generic competitors, these rules are not confined to any particular type of organisation, so would be relevant, for example, to medtech, biotech, research organisations and universities and so on. So it's a very important development for this sector in the round. The other observation I would make before turning to what it is the CMA has been looking at is really just to point out that organisations and firms can be competitors on labour markets, even if they're not competing head to head in terms of the actual goods or services they supply in the so-called downstream market. And this is because you could have a situation where firms are competing to win and retain talent from a pool of individuals, where that pool spreads across a number of different market areas. So you need to think about this in a slightly different way from the usual kind of competition analysis. So the main risks here that the CMA has called out are the following. So first of all, no poaching agreements. So this is where firms or organisations agree not to approach each other or to hire each other's employees, or not to do so without each other's consent. Secondly, wage fixing agreements. So when firms agree to fix employees' pay or other benefits or conditions of employment, which might include, for example, setting the same wages, setting maximum caps on pay, or sharing commercially sensitive information about those things. So it could be around wage levels, timing of salary increases, or intentions to change or bring about online new terms and conditions of employment. And an agreement, of course, for these purposes is very broad. It doesn't just mean a written agreement, but it includes a nod and a wink, an understanding, a verbal agreement about what is going to happen next. These rules also extend beyond salaried employees and could capture freelancers or other sort of contract workers, so potentially very broad. And the fact that the aim of some form of understanding might have been to ensure that workers are paid fairly, or that the net result is that wages go up, benefits increase in some way, is actually no defence of itself to there potentially being unlawful conduct. The CMA has been very clear that this kind of conduct is a business cartel and harms competition, for example, by distorting the operation of labour markets or potentially also harming employees. I would say, as an aside, that the competition authorities are generally not concerned about non-compete clauses agreed between an employer and an employee, and genuine collective bargaining agreements are also outside the scope of what the authorities are thinking about at this time. So it's not just a hypothetical risk. The CMA does have a number of open investigations on its books. So it's currently investigating alleged anti-competitive practices involving multiple media producers and broadcasters in relation to the employment of staff and the purchases of services from freelance operatives in both sport and non-sport. And another investigation which has been expanded to include suspected reciprocal arrangements for the hiring and recruitment of staff. And this is in relation to the manufacture of ingredients which are used in fragrances. So nothing specific as yet to life sciences, and we're not aware, as far as we know, that the CMA is specifically looking at this sector. However, the CMA has said there are more cases in the pipeline, and it does seem to us that there are clear risk areas for the life sciences sector. If you think about there being competition to attract and retain talent, potentially from very limited pools of individuals, so thinking about sort of limited skill sets, research scientists, data scientists, where there may be only a very small subset of people who can actually deliver those particular sets of skills and services. You could see how there may be conditions which are more conducive to collusive outcomes. Similarly, also, I think you need to think about this in terms of sort of more corporate or back office type functions. So, for example, IT specialists, even legal teams, where again there may be a smaller pool of available employees out there, and again collusion around how those types of employees are attracted to the sector or retained could also fall within the scope of this hot topic.
So, how should businesses then in the sector mitigate the risks of action?
Yeah, so I think there are two things businesses can think about. So one is a question of mindset, and one is more practical in nature. I suppose in terms of the mindset point, first of all, and having spoken to other businesses about this thorny topic, there does seem to be a feeling that for HR professionals, the sense of adding value to a business comes from being well plugged in understanding what market trends are and what rivals might be doing in the people space. So therefore, that there is an element of shifting the mindset from being highly well informed and using connections to bring to the boardroom insights into what rivals might be doing in terms of hiring and retaining people. The second aspect, I would say, is actually much more practical in its nature. And I'd point out that the CMA has published guidance on how to avoid issues in this area. So it's well worth having a look at the website where you can find them. But of course, there are also things which can be done in practical sense in terms of, I suppose, a deep dive into what organisations do now and whether there are any risk areas in terms of their existing processes and protocols. So, for example, reviewing the processes by which salary increases are agreed internally. Do these involve benchmarking, for example, or is there an element of testing the water with competitors? If so, what does that look like? How does a company go about deciding how to hire, bring people in? How is information about the relevant pool of talent collated and where does it come from, importantly? Do HR professionals go on to industry groups or briefings about what's going on in labour markets? If so, who goes, what happens? Of course, training is always very important so that HR professionals know where the red lines are drawn, and also having robust processes internally so that HR professionals can flag up questions or raise concerns would always be recommended. I would also say that, as is the case with any kind of compliance programme, the deep dive is always the first step, but there has to be a process of keeping that under review and refreshed so that any processes do remain fit for purpose. And in this area, I would say that's particularly important because I suspect this will be an area which will move quite quickly. And when the CMA does reach some decisions, which it will do in due course, firms will need to be aware of what those decisions say and to make sure that their processes, do match up and address the risks and harms that the CMA identifies.
Oh, fantastic, good. And I think this will evolve over time, won't it? So again, it's keeping a beady eye on how things develop. I mean, one of the other big seismic changes within the competition law space has been in respect to the Digital Markets Competition and Consumer Act, which came into law or the end of last month. And obviously, I think we're all aware this is a huge piece of legislation covering a broad range of topics. We're not focused on the consumer parts of the Act. We plan to do sort of further sessions around that, because I think we do feel that there is quite a big impact on the sector. So we will be following up on that. But I'm keen that we focus on those sort of the competition law aspects now, Kate, and how that piece of legislation impacts the sector.
Sure. I mean, you're right, James. It's an absolute monster piece of legislation. It's 400 odd pages. It's absolutely enormous and long awaited. I mean, a lot of the discussion about this act has been around the creation of a new competition regime for digital markets, and unsurprisingly, that's been a real focus. But, and importantly for this sector, it's really important to remember that the act does bring about changes which do represent the most significant changes to the UK's competition regime since 2013, which are relevant to all sectors of the economy and again, all parts of the life sciences sector. So there are two areas I'm going to talk about, one being changes affecting the merger control rules, and the second, to mention briefly, changes regarding the investigations part of the UK regime. So first of all, the merger control changes, obviously these will be relevant to any organisation who may be planning M&A and activity, but equally remembering that in some circumstances, the creation of JVs can also fall within the scope of the UK's merger control regime. And these changes are expected to come into effect in the autumn, so there is some time to think about it and plan ahead. I suppose the good news in some respects is that the UK's regime remains voluntary and non-suspensory. So that does mean that when embarking on a transaction or thinking about a JV, for example, there remains no obligation to go and talk to the CMA about that. And it is always a assessment of risk in light of whether a particular transaction gives rise to competitive harms, as well as the risk of the CMA being interested. These always need to be balanced up in the round in deciding on an appropriate strategy. However, and this is really important for the sector, there is a new threshold which is introduced, which is aimed at capturing so-called killer acquisitions. I mean, this term is probably familiar to many people on the call, but these, in brief, are acquisitions which are of typically small, very innovative startups when they are acquired by a larger, more established player for a very high value. And there has been this concern in the UK and wider afield that the current regimes as they stand were just not picking these up, and there was an enforcement gap. The reason being that because these startups generate very little or no turnover, they just fell under the radar of the thresholds. And for life sciences, where the sector is characterised by innovation, by startup companies, of course, taking out a target who has these characteristics would remove innovation from the market and potentially a future source of competition. So the Act seeks to address this by enabling the CMA to review an acquisition where at least one merging party has an existing share of supply of 33% in the UK and UK turnover of at least £350 million, and the target simply has to have a UK nexus. So I would say there are a couple of things to draw out here. So first of all, the buyer alone could meet that threshold without there being any increment to their own share of supply resulting from the transaction. So that is one significant change. And secondly, I would say that the concept of a UK nexus for the target is potentially very low, and the 33% share of supply threshold could also be potentially very broad. So the CMA, under the existing share of supply test, has a very wide discretion when deciding whether or not it applies. And I think a really good example of that was Roche and Spark back in 2020, when the CMA did take an expansive approach to the existing share of supply test and found jurisdiction in that case on the basis that both firms were active in the supply of Hem-A treatments in the UK, notwithstanding that the US-based target Spark was not engaged in the commercial supply of any goods or services at all in the UK and didn't actually generate any turnover in the UK either. The CMA simply said that the commercial reality from what they had seen was that both Roche and Spark had altered the way in which they were competing against one another in view of their Hem-A treatments, and that, and I quote, competitive interactions between firms should not be reduced to overlaps in directly marketed product. And the CMA found that the 25% share of supply was met by reference to the number of UK-based employees engaged in activities relating to certain Hem-A treatments. It was a really kind of expansive application of the test. And I think with this new test, it will remain to be seen quite how the CMA goes about applying it. But I think my view would be that it adds another layer of potential complexity to assessing whether deals are caught by the UK's merger control regime. On the other side of the balance, however, I think there are some welcome clarity in other respects, which could be helpful for deals in this sector. So there is an uplift in the turnover threshold. So a transaction will qualify for review where the target generates a UK turnover of 100 million. So that's up from 70 million. That's to account for inflation. There is a new safe harbour for small deals. So where each party has a UK turnover of less than 10 million, the deal will be exempt in its entirety. So I would say that's also good news. And there are also changes to merger control processes, which are aimed at making the whole system, the UK merger control system, much more efficient and flexible, which again, I would say is a welcome change, particularly when parties are doing an international deal and there are different timetables running in parallel in different places. I think it's very welcome that the change will bring about a means to speed things up, particularly in more challenging cases.
That's great, Kate. So if you're planning a M&A transaction, JV transaction, what do you really need to be focusing on?
Well, I would say that my key takeaway would be start early, whether you're on the buy side or the sell side. Early planning about whether a transaction might qualify for review by the CMA, bearing in mind this new threshold would be absolutely key, because if there's a risk that that threshold might be engaged, there does need to be proper planning to understand whether any substantive concerns might arise, and if so, how to deal with the UK's CMA, even more so in that international context where there might be multiple filings in going on in different places, to make sure that there is a fully joined up appropriate strategy. But just a couple of words before I conclude, if I may, just on the investigation side, which I think are important to bring out, in particular, given we started off this conversation today talking about enforcement activity in the UK. So on the investigation side, so when the Act comes into force, there will be an expansion of the territorial scope of the UK's competition rules affecting anti-competitive agreements. So the Chapter 1 prohibition, which prohibits anti-competitive agreements, will apply to agreements which are implemented outside of the UK, where there are or likely to be direct, substantial and foreseeable effects within the UK. I mean, this brings the UK into alignment with most important jurisdictions around the world, including the EU. Of course, going to be very important for life sciences businesses which are domiciled outside the UK, but maybe implementing agreements which will have some impact here domestically. There will also be enhanced investigative powers for the CMA, including powers to issue information notices, which could compel companies domiciled again outside the UK to produce documents held outside the UK in relation to a domestic competition or investigation. So again, that raises the compliance burden potentially very significantly. And finally, across the board, the CMA will gain the ability to impose enhanced fines for procedural infringements. So at the moment, if a company fails, for example, to comply with a compulsory information request, a business could be fined a fixed cap of £30,000, and that could be increased to a cap of up to 1% of global turnover. So, potentially an eye-wateringly expensive fine for not complying with the CMA's procedures and processes. And again, I would say this really kind of ups the stakes in terms of how businesses in the sector deal with inquiries if they are subject to a CMA investigation.
Thank you. That was excellent. Should we turn to questions now? So there are a few questions sort of popping up. So the first one really is just to get your sense in terms of trends in relation to the NSIA. So the National Securities Investment Act, requiring notification clearance for certain cases. So are you able to sort of talk around any movement, any changes, any trends there?
Yeah, I can just give you a quick snapshot on that. So I suppose the most notable change or development was the fact that at the end of last year, there was a call for evidence from the government to get a sense of how well the regime has been working, and a response was published a couple of months ago in April 2024, with the government followed with publishing updated guidance around certain aspects of the regime. I mean, in relation to the life sciences sector, I would say that probably the most relevant point to come out of that consultation and the response was that the government will be launching a consultation, they say by summer 2024, on the mandatory areas, so that's 17 sensitive sectors, where if you are buying a target operating one of the sectors, you have to make a filing. And the response noted in particular that one of the areas expected to be within that consultation is around whether more clarity is needed in respect of the artificial intelligence sector, which is one that we come across in a fairly regular basis when advising companies in this space on whether a transaction falls within the Act. I would also be keen to see whether there's anything in the consultation around synthetic biology, which of course
that's the other big one for us.
The other big one for you, exactly. I mean, the other point I would say is that the government has said there's been, to date, over 1,700 notifications, but just 20 final orders. So, I mean, around 1% of notifications have resulted in some form of final order. So I think the message from that is that the regime is working quite effectively in the round. I mean, I would say again, a bit like merger control, it needs to be on the deal checklist. It's not going away. In the response, talked about there being a sort of deterioration in macro, kind of global factors, more uncertainty, and therefore I don't think the regime is going to shrink. If anything, in some areas it may be expanded, but I would say I think there will be some more clarity coming down the track after this consultation. So watch this space.
Yeah, absolutely. I think the other point to sorry, Isabel.
Sorry, James. I just wanted to pick up. There's a question around that might be one for Nicola, actually. If you were talking about the different authorities looking at the disparagement cases, and the French authorities, the UK, the European, perhaps you could. I mean, what kind of collaboration is there between different nations? And now the UK is no longer part of the EU regime.
Yeah, it's an interesting question because obviously in the Vifor cases we highlighted, the conduct is the same. It has obviously been carried out on a kind of pan-European basis, European being Europe geographically. And obviously after Brexit, there is scope for divergence between the UK and the EU authorities. That said, they still, in practical terms, they want to cooperate. There's not sort of divergence for the sake of divergence. And I think where there is that kind of pan-European conduct, if the for Vifor, if the commitments are accepted following consultation and they are then implemented by Vifor, they'll be wanting, I expect, to bring that to the CMA and have a conversation which says, look, we've entered into these commitments, we're going to bring the conduct to an end. And I think the CMA would take that into account and potentially follow the same line. They wouldn't have to anymore. So the CMA is not bound to follow the decisional practice of the European authorities anymore, but they're very mindful of the mess that can result when there is material divergence, and they will, they'll be keen to be efficient and to show that they're on the same page, and they are in regular contact with their with the European authorities, not on the same kind of formal footing as they used to be when we were part of the EU, but certainly professionally at least they want to be aligned, and you would expect that unless conduct was having some unique effects in the UK, that meant that the CMA had to take different action to address that specific UK focused conduct. You would expect a certain commonality of thought, given that our principles, the principles for competition law enforcement, are the same across the whole of Europe, including the UK.
Fantastic.
Yeah. Kate, maybe, I mean, perhaps you could comment on divergence from the perspectives that you were commenting on earlier. I mean, are you seeing divergence in terms of enforcement? I mean, sometimes one gets the impression there's a bit of, vying for position between regulators, but yeah, what are your thoughts?
Well, thinking about the labour market points, I mean, the US has been a trailblazer in this area, and has been very active for some time. I mean, you might get the sense that perhaps some other authorities are playing catch up a little bit. But again, I mean, in the labour market space, I mean, the risk areas which all the authorities are looking at has been pretty clear cut, to be honest. And I wouldn't expect there to be significant divergence in terms of things like no poaching or wage fixing. It seems in the competition harm seems quite easy to kind of understand and apply, notwithstanding domestic conditions of competition. we'll have to wait and see, I think. But I think certainly the starting point will be that most authorities around the world will be having sort of a laser sharp focus on the same kind of issues. And again, as Nicola had said, I think we'd be keen to kind of develop decisional practice and thinking in a sort of aligned manner. I mean, some forums, for example, such as the International Competition Network, you know, they work very effectively to kind of enable enforcers around the world to sort of share the work they're doing and their best practices. And I expect that will fully continue going forward. I think authorities around the world do like to be broadly aligned where possible.
Great, fantastic. I think we're there at the end of Q&A. There's no other questions in the chat. So all that I think leaves for us to do is to thank Kate and Nicola for this session. It's been a great discussion. The session is recorded, so you'll all get a link to the recording. Conscious there's quite a bit of information there, isn't there? So it's a case of maybe re-looking back at some of those key take-home points. So our next Life Sciences Legal Forum is in September. That will focus on regulatory trends within life science, and will focus both on pharma and devices and other aspects as well. You will all receive a feedback form after this session. As I say, those are useful to us, so they tell us sort of how we're doing, but also in terms of ideas for future events as well. And as I say, this is a topic that constantly comes towards the top of people's feedback. So thank you very much for attending today, and have a great rest of the day. Thank you.